Let's check one more person. Ms. Hall, can you hear us?
I can hear, Judge.
Here.
It's all the way down to 36, isn't it?
Okay, let's leave it. It's
That's good,
to be
okay.
able to hear what's going on. So,
Right,
everyone's happy.
perfect.
Thanks, Glenn.
I apologize, it was wet water stuff over here, so I just had to move from here to here, that's why.
That's
So,
fine.
like,
No,
sorry.
it's all good.
Okay.
We will work through this. So let's dismiss that and get started. We have a calendar with some inmates here. Mr. Matt, Mr. Brown, and I think Mr. Humans are all here. Is that who you got?
Yes. Matt Brown, yeah, Humans.
Excellent. Okay, my thought is that we go in the order in which the calendar was published, but we control it more than when we're doing the jail Zoom calendar. We've got Mr. Matt, Mr. Brown, Mr. Humans here, and then Ms. Brown has two matters. I don't think she's going to be coming here. So Ms. Brown is in custody, part of her evaluation. What's the status of Ms. Brown?
Your Honor, in very unexpected circumstances, a nonprofit posted Ms. Brown's bond, which I've never seen happen before. And so she was released to the street. She's not competent. And then they lost track of her. And they did not consult me or my social worker about any of this. So we don't have a means to communicate with her right now.
What's the name of the nonprofit?
Saving Our Sisters.
Okay, and was that a program that your office was trying to line up for Ms. Brown?
No, we had never heard of it up until then. And when it took us forever to actually figure out what had happened. And by then they gave her a phone. She was supposed to be living there. She turned off the phone and walked off. So I don't know why they did that and why they didn't communicate with me or my social worker, but unfortunately she's now just on the streets.
Got it, okay. Well, I have some thoughts about what we ought to do. Ms. Hall, anything you want to add about this unique and unexpected development?
No, Your Honor, me and Ms. Patel spoke about it last week. Just like her, I didn't expect for her to show up, especially with her being incompetent. So I'll leave it to your discretion, Your Honor, how you want to move forward.
Ms. Patel, where were we in the process? Ms. Brown had her evaluation, or we were waiting on the evaluation?
She was evaluated and she was waiting to be restored at Georgia Regional. And so we were just waiting on a bed to open up at Georgia Regional.
Got it. That was my recollection, that I'd entered an order that directed DBHDD to take charge, and then they just need the space. Okay. I will look into having some words with Saving Our Sisters and see what we can do. And Ms. Brown just has two cases, the two that are on the calendar.
Yes, Your Honor.
Okay, all right. Well, that takes care of that. Did you have anything else on the calendar, Ms. Patel?
No, Your Honor.
All right, well, thanks for dialing in. And we'll be in touch about what's next for Ms. Brown.
Thank you, Your Honor.
Ms. Nelson, was your understanding that Mr. Arnold was going to be here, or was he going to dial in?
I believe he was going to dial in. I'll double check with him, but I believe he was dialing in.
Okay, this has to do with Mr.
Because he was going to have some witnesses as well. He was trying to go forward on a bond hearing.
Okay, I didn't know okay, did you know there might be a bond hearing, Ms. Hall? For Mr. Mack? You're on mute.
Your Honor, I'm aware now. I found out earlier today, so I'm aware.
Well, we'll see. There's been a lot of transition in Mr. Mapp's case. He had a different lawyer until just a day or two ago. So we'll see if Mr. Arnold shows up. We'll need to bring Mr. Mapp out into court at some point, but it sounds like we're not in a position to move forward with his case first. So Ms. Snyder is on. Ms. Snyder, should we do Mr. Brown's final plea?
Sure.
Okay. Ms. Hall, Ms. Snyder had a chance to meet with Mr. Brown in person here this morning. The deputies were good enough to bring him out so that Ms. Snyder and Mr. Brown could talk. I'm gonna have Mr. Brown come out in just a sec and we'll handle the final plea. My understanding is that the case is not resolving, but at least we'll have taken care of final plea and Mr. Brown will be all that more ready for trial if that's where we're going. Is Mr. Dean in the same space now? Has he already had final plea, or where are we with that, if any of you happens to know?
He, Your Honor, he shouldn't have had final plea. Both cases were tracking together. Mr. Dean is in DOC custody. Maybe that has a lot to do with why he's not scheduled now, but past court proceedings, they were together.
Okay, I may have misheard. I thought someone said he was on bond.
I misspoke this morning, Your Honor.
Okay, he's not here, but he is definitely not walking the streets.
Right, right.
Okay, let's see, there's a scheduling order in for Mr. Dean that had, all right, so there are no motions filed. This case ought to be ready to be on a final plea as well. Oh, there's a date. It's October 8th. And we'll need to see if, Ms. Nelson, were we going to be doing WebEx on October 8th?
For which defendant? I'm sorry, Judge.
Mr. Dean is Mr. Brown's co-defendant, and Ms. Hall explained that Mr. Dean is in the custody of the Department of Corrections. I had asked him.
No, I did not know. I have my notes. We're assuming that he was on bond. So no, I did not know he was in the Department of Corrections. So that case will probably be taken off unless they're resolving it.
Okay.
I'll double check you all. I thought I was certain that he was on in DOC custody. I'll check to make sure that I didn't miss.
Earlier this year, I'm looking at a production order that we did, and it's got a GDC number. Doesn't mean that he hasn't gotten out, but let's just figure that out so that he is tracking as closely in time as possible with Mr. Brown. Ms. Snyder, do you have a sense of whether, if this is a trial, it's one where the two will be tried together, or is this one that's ripe for severance?
I think they should be tried together.
That was my recollection of when we had a bond hearing for, I assume it would have been Mr. Brown.
Well, Judge, were we under the policy that we weren't handling any of the Department of Corrections cases unless they were something that was going to resolve the case? I guess probably I'm asking for scheduling purposes if we're going to track Mr. Dean with Mr. Brown.
I think we need to do his final plea hearing, and that wouldn't take very long. I don't know how much of a production it is for the Department of Corrections. We would certainly ask the sheriff to get Mr. Dean in front of a camera for 5 minutes for a final plea. So maybe you can reach out to Ms. Beasley to explain this is not likely to resolve the case. Is the offer for Mr. Dean all that different, Ms. Hall, if you're comfortable disclosing?
No, they're the same. They're both life offers, Your Honor.
Okay, so yeah, Devontae Dean is currently at Coastal State Prison And he can be released as late as the end of this, his release date is the last day of this year. He's at Coastal State. Let's please figure that out. I know we went down a little bit of a rabbit hole here, but I would like to do Mr. Dean's final plea. And let's figure out if Department of Corrections has any heartburn of doing that WebEx. That's Mr. Franklin who has that case?
That's correct, Your Honor.
Okay. Because that's certainly something we could do remotely. We just need to make sure that it's okay to set up a WebEx for something as quick as a 5-minute hearing.
Okay, I'll check into that, Judge.
All right, thank you. Let's bring Mr. Brown out.
Your Honor, I'm so sorry to interrupt. I'm Attorney Will Arnold. Good to see you again, Judge. I was logged into a Google Meet. I got a Google Meet link, and I've got 2 witnesses for today who are also over in that Google Meet link. I'm not sure if you already called my name or my client's name or not, Judge.
So hello, Mr. Arnold. We never, ever use Google Meet, so you did not get that from us. We are always using Zoom.
Yeah, I thought it was a little weird. I'm not sure where I got it from, but there's a meeting going on right now. Nobody's there. I'm sorry.
Yeah, well, you were there, but here we are on the Zoom link.
Yes.
And we will get Mr. Mapp out here in a minute. You weren't here when we got to his position, so we're going to handle Mr. Brown, and when we're done with that, then we can talk about Mr. Mapp.
Thank you, Judge.
Okay. Are you all here for Mr. Mapp? Okay. Does Mr. Arnold know you're here? Okay. We'll clear that up when he's back on. But he can just sit, whatever is easier for you guys. Okay. Well, is the screen on there? Or why don't you go to the podium, Mr. Brown? That way you'll be able to see and hear Ms. Snyder. Thank you. Great. Can you see? Well, I guess that's the screen you need to see the big one now. All right. Okay, this is position 2 on our calendar. It's 20 SC 174164, State versus Antonio Brown. Mr. Brown is here in court. Good afternoon, Mr. Brown. Mr. Brown's attorney, Ms. Snyder, is appearing remotely, but earlier today, while she was here in courtroom 1D, Mr. Brown was here in courtroom 1D, they were able to meet privately. Is that correct, Mr. Brown? Did you have enough time to speak with Ms. Snyder? You understand what we're doing today? Okay, well, I'll explain, but we're not going to talk substantively about your case. We're not going to say who had a gun or who did this or that. It's what we call a final plea. It is the last day you could choose to enter a plea while you have the right to withdraw that plea if you're unhappy with the sentence you get. You can always enter a plea. You may decide to enter a plea tomorrow, next month, just before your trial starts. But up through today, if you entered a plea and I sentenced you more severely than your lawyer asked for, just as an example, let's say that your lawyer said, Mr. Brown should serve 1 year in jail. That's what the sentence should be. I said, you know what? This sounds more serious. This woman got shot. I'm going to give him 2 years in jail. 2 is more than 1. You could say, no, thanks, Judge. I was ready to take 1 year. I'd rather go to trial if you're going to give me 2 years. And you'd be able to withdraw your plea. No one will tell the jury that you had tried to plead guilty or anything like that. So that's what changes after today. After today, you can still enter a plea, but if you don't like your sentence, you're stuck with it. Just like if you went to trial. If you have a trial and you're found guilty, you don't get to back out of it if you don't like the sentence. Okay? But what we need to find out first from Ms. Hall, who's the prosecutor, she's on the screen as well, is what the state is recommending in your case. You're charged with armed robbery, aggravated assault, and possessing a firearm. Ms. Hall, what is the state's recommendation if Mr. Brown wanted to enter a guilty plea today?
The state's recommendation today for the armed robbery charge is life, Your Honor.
Okay. Well, that's the highest they could recommend. The most severe sentence you could get if you pled guilty or a jury found you were guilty, Mr. Brown, would be a sentence of life. So the state is recommending the max. You could get life for the armed robbery if the aggravated assault didn't merge, and don't worry about what word merge means, but if it didn't, you get another 20 years, and then the gun charge is 5. So I guess in theory, you could get life plus 25, but the aggravated assault might combine with the armed robbery. And either way, life is a big number, so I can understand how that's probably complicated for you to process. Do you understand what the state's recommendation is? You understand it doesn't bind me. If you were to enter a plea today, I could sentence you to life, but I don't have to go along with what the state says. I might hear more about you and your situation and say, I think it should be 20 years or 10 years, but I'm not bound by what the state offers. You understand that? The other thing you need to, I need to make sure you understand is that this state's offer of life is open only for today. I don't know that they can make it any worse than that, but you wouldn't be able tomorrow or next month to say, oh, wait a minute, I do want to work the case out, and I want that deal the state was offering. Not really offering you a deal, but they're not required to. But what the state is offering today is good for today only. You understand that? Ms. Snyder, do you feel like you have all the discovery that you would expect to get in this case?
Yes, sir. I believe I do now. I was able to pick up the digital discovery after I left court this morning. I haven't had a chance to look at the disc to see what's on it, but I do have it in my possession. And I'm assuming that it has on it what the certificate of service says is on it.
Okay. Does that digital discovery include anything that in your mind could possibly change your thinking about the case such that you would advise Mr. Brown differently than you may have advised him today? Or do you have a pretty good idea of what's on the disc?
I have a pretty good idea, but there is a video and of the Lennox parking lot, and depending on what that video shows, it may change, but I don't think so.
Okay. All right. Is that all of the discovery? By which I mean, have you received nothing until you got that disc? Or that disc was supplemental discovery and you already had some discovery in the case?
I had the paper discovery when it was served on me in March. I was just waiting for the jump driver disc to come in the mail, but given the pandemic and our office being complicated, I just never received it, and we didn't realize that until this showed up on a calendar. And so I spoke with Ms. Hall, and she had her paralegal get it to me.
Okay. All right. Well, if you decide, Ms. Snyder, that there's something in that discovery that fundamentally changes your outlook on the case such that you would encourage Mr. Brown to do something other than what you and he are going to tell me in a moment, let's have that conversation, and we could always revisit should he have a second final plea. Given that the officer's life, I don't see any kind of discovery short of a on-scene confession to 10 officers that would really change what you and Mr. Brown have decided. But I'm happy to revisit it if we need to.
Yes, sir.
All right. So Mr. Brown, you understand the state's recommendation. They recommend life. You pled today. You understand that if you enter a plea today, you can withdraw it if you don't like your sentence. After today, you can always enter a plea, but you don't get a withdraw if you're unhappy with the outcome. You understand all those things? Okay. So Mr. Brown, do you want to enter a plea today knowing what the state is going to recommend, or would you rather go to trial when we're able to try this case? Okay. I don't know if you could hear Mr. Brown, Ms. Snyder, but Mr. Brown indicated that he would rather go to trial than enter a plea today with a recommendation from the state of life in prison.
I could.
Does that surprise you from what you and he talked about earlier today, or is that consistent?
No, that's what I expected him to say.
Okay. Mr. Brown has a question though. What's your question, sir? Yes. What was the second thing you just said? So all you're doing today is deciding, do you want to enter a plea knowing what the state's going to recommend, or no, right now, Judge, I'd rather have you move the case towards a trial. A trial would be a jury comes in, you and Ms. Snyder fight the case in front of a jury. You just mentioned the word dismissal. The case could be dismissed. I don't know that that's what the state would do in this case, but only the state can dismiss the charges. An example of when they do that would be you and your lawyer are able to show them that you were in Louisiana the day of the shooting. Here's a video of you in Louisiana the day of the shooting. You couldn't be at the scene. And the state might say, well, we're going to dismiss the charges against Mr. Brown. We're still going after Mr. Dean. But dismissal is pretty uncommon. The fight in the case is what will be next. You and Ms. Snyder will talk about, all right, what's our defense? I wasn't there, or it's a bad ID, or it was self-defense, or it was all Mr. Dean, and I was just along for the ride, or I was scared of him and he threatened me. There are as many defenses as there are people in the world, and you and Ms. Snyder will talk about what you want to do with that. This doesn't mean that you are committing to a trial. You could still work the case out. The only thing that's changing is if you work the case out, you're going to enter a plea, because those are really, other than dismissal, which could happen but would surprise me, is you're going to plead or you're going to go to trial. After today, if you plead, I will gladly take that plea. You just don't get it back out of it if you're unhappy with how the plea goes. That's the main change. Got it? All right. Ms. Hall, anything else in Mr. Brown's case?
Nothing further from the state, Your Honor.
All right. Ms. Snyder, anything else?
Nothing further at this time.
Okay, Ms. Hall, we will work with you and Mr. Franklin to line up this same conversation for Mr. Dean. Hopefully the Department of Corrections will let us do that in the next few weeks.
Okay, Your Honor.
All right, thank you so much. So, Mr. Brown, you're going to go with this deputy, and Ms. Snyder will come see you soon to talk about this other discovery, okay? All right, Mr. Arnold, you there?
I am, Judge.
Great. There are two people in court right now for Mr. Mapp.
Yes.
Is that who you're looking for, or do you have people with you as well?
I actually, his mother is on a Zoom. I'm sorry, we did receive, and I'm not sure if it was a mistake or not, or if it just happens when we get the meeting invite through Google, but it was a link for a Google meeting, and that was forwarded to his mother. If the people in the courtroom are able to call her, I'm afraid to get kicked out of this meeting. If the people in the courtroom knows her mother can give her a quick call and just let her know that we emailed her the Zoom link, then that would be great. In the meantime, Judge, I'm ready to make my announcement once Mr. Mapp is brought out.
Okay, let's figure out who's here. You are, okay, so Mr. Mapp's father is here. You're gonna reach out to his mother? Okay, he's reaching out to Mr. Mapp's mother.
Okay, she says she's trying to log on right now.
Okay, we'll sit tight.
Now,
Great, Mr. Mapp, why don't you take a seat for right now? In a little bit, you may be up at the podium so that you can be heard by the folks who are not here. I'm just looking at your case.
And I guess just as a preliminary matter, Judge, I spoke with the state earlier. There's been, I think, 4 attorneys on this case. Me being the last,
How are you about?
Attorney Arrington has filed his withdrawal. I guess I should have filed a substitution. I did file a bond motion, which I'm going to be asking to be heard on. In regards to the final plea calendar, I would be asking Judge to be put on another final plea calendar if at all possible, just because I got into the case a little late. I diligently harassed all of the other attorneys trying to figure out who actually had the discovery. After speaking with the state, it's my understanding that discovery has kind of been ongoing. As a matter of fact, today there was some supplemental discovery that was filed. And I would, as I've had a chance to review the initial reports, I have not had a chance to go through a lot of the other items that my understanding is that the state has. So I would be asking, Judge, if we can be put on another final plea calendar, and kind of that supporting me asking for a bond this late in the case as well, Judge.
Okay, I'm gonna unwind that a little bit. First, as for representation, I do see in the docket that you filed an entry of appearance back in July. It was
Yes.
July 16th was
Yes.
when you appeared. Interestingly, only 2 weeks before that, Marvin Arrington, who is also a county commissioner, so it's always interesting when he's going to represent someone in front of the judges whose salary he partially determines. He filed an entry of appearance. So I guess Mr. Mapp been out there looking for different attorneys. But Mr. Arrington filed a motion to withdraw about a week ago, which would leave you now as counsel of record. That's great.
Yes.
And I will enter an order permitting Mr. Arrington's withdrawal. I just want to ask Mr. Mapp about that first, because you're right, Mr. Arnold, there. Mr. Mapp has had Ed Adams, Ted Johnson, very briefly, apparently, Marvin Arrington Jr., and now you. Mr. Mapp, some of this may have been your parents helping out, but I need to know who your lawyer is so that we're talking to the right person. Is Mr. Arnold, the gentleman whose voice we're hearing here, is that your lawyer? Okay, all right. Then we'll let Mr. Arnold keep talking today, and I'll enter an order that gets Arrington off the case so that the file is a little bit clearer. Mr. Arnold, have you been able to get that discovery from Adams or Arrington or Johnson?
I have not, Judge. They seem to be confused as far as who got the copy from whom, Judge. So we've called all of them, and at this point, I've just spoken with Cassie. She's making it a lot easier for me, so she's going to get me everything. She did go ahead and, like I said, send me some reports, and I just got an email service for some supplemental discovery. So our text a few hours ago, she said it's just too much to, we were talking about the case. She said it's a lot of items that I need. So she's going to get it all for me, Judge.
Okay, thank you, Ms. Hall. My guess is this is not the first time in this case we've had to pull together discovery. This will be the last time we have to do it. So if you tell me you gave everything to Mr. Arnold, if Mr. Mapp decides to go shopping again and get another attorney, we'll know that that attorney is going to have to get it from Mr. Arnold and not from the state again.
Thank you, Your Honor.
How much time do you need to get Mr. Arnold everything?
I have already started working on that, Your Honor. It could be ready as soon as the end of this week. I had my legal assistant getting everything. I just assumed that it would be an issue with discovery. So last week I reached out to see if she can go ahead and just recopy the entire file. She was in the office yesterday, but she didn't finish it because she was copying. It's a lot of interviews and digital things that Mr. Arnold would need. So she didn't finish it, but she does go back into work on on Thursday. So I'm assuming that it'll be done that day.
Okay.
So I would say at the very latest, the following week.
Okay. And take the time you need. I ask because I would give Mr. Arnold a little time to digest it all before we put this back on for a final plea. I think it's a fair request, but I don't want it dangling out there forever. If we're going to need to get Mr. Mapp a trial, I'd like to have that sooner rather than later, when we get jurors sometime soon. So what we'll do, Mr. Arnold, in a minute is talk about bond, and we'll get on the record for that. And then Ms. Nelson will likely put this down for a final plea in late October, about a month out from now. I don't know how closely the other attorneys looked at the file to see if there were evidentiary motions to be filed. I don't know if your client gave a statement or if things were seized. But what I'd ask you to do when you're looking at this discovery is focus on that first. Because if there are motions we need to hear, that we can do. We don't need a jury for that. And Mr. Matt's here in court. We could bring them back on a Tuesday. We get inmates every Tuesday in this division, and we can have a hearing if we need to do it. So please focus on that. This case has already passed the deadline for motions to be filed, but because we've had musical attorneys on the defense side, I'll give you a little while to look at that. And I'm not flagging that because I think there ought to be one. I don't remember anything about this case. I'll be refreshed in a minute when we talk about bond, but there may not be a good basis for an evidentiary motion.
Well, I appreciate that, Judge.
Okay. Having said that, and before we get on the record, Ms. Hall, you mentioned that you gathered maybe earlier today that we might be talking about bond. Are you ready to do that today, or do we need to reset this so that you can have witnesses or let the alleged victim know, or where are you on this?
Your Honor, we can move forward with bond.
All right. Well, let's do that then. Mr. Arnold, we'll start in just a second. I just need to make sure Mr. Matt is all right proceeding with you being not next to him. Mr. Arnold, you have a couple rights associated with a bond hearing. Okay, get on the record. Yeah, excellent. Thank you. In your case, one is that you have a right to be here in court while we talk about your bond, and here you are in court. Another right you have is to have Mr. Arnold sitting next to you, so that if he's got a question, he can just lean over and ask you, and vice versa, you could ask him a question. For lots of reasons, Mr. Arnold is remote and not here in court. And that's okay as long as you are okay with that. Are you okay going forward with the bond hearing, having Mr. Arnold appearing through the screen and the speakers? Okay. Normally, I'd say if you two needed to speak privately, we would make that happen. That would be complicated. We'd have to get everyone out of the courtroom so you could do that. So if you have questions for him, it's fine to ask him, but just know that everyone else is going to hear the questions as well. So if it's top secret, don't ask the question. Okay. All right. Mr. Mapp has made clear he's comfortable going forward with Mr. Arnold being online rather than here in court. Mr. Arnold, tell me why you think Mr. Mapp ought to get a bond.
Okay, thank you, Judge. So my client's 20 years old. He's completed 2 years of college. His last college was Atlanta Area Tech. He started off at Albany State. He has all of his ties to the community here in Fulton County, born and raised here in the West End area, Judge. So he has no criminal history. Okay, this here is my understanding is his first mistake. Well, it's the first allegation against him. Okay, and if that allegation were to somehow be substantiated, it would be his very first mistake. So he has no criminal history, Judge. So on the Aiella factors, considering whether he's a flight risk and whether or not he's at risk of committing another crime, Judge, I believe that there's nothing that can be said by the state to suggest that he would. In terms of danger to witnesses and danger to the community, I do have a great program that I would like to tell you about. I know you're familiar with Next Level Boys Academy. Gary Davis is actually on the line right now, and he'll speak a little bit to that once I call him, Judge. But he's going to be heavily supervised, not only by his mom, but also by mentors and people who are in his life, providing him with job resources, providing him with any type of treatment or any type of resources that he needs to go ahead and make sure that he's productive while on the outside and not sitting idle. I know that's one of the court's concerns. Judge, an ankle monitor, if appropriate. His family, they don't have a lot of money, Judge. I'm not charging them a ton of money. I guess I'm working low bono here, but still an ankle monitor if necessary. If the court felt that that was necessary to keep him supervised, we would not object to that, Judge. And as it regards to actual facts of the case, he is presumed innocent. However, just speaking to the facts of the case, Judge, it's my understanding that this stems from a December armed robbery where five individuals were involved. My client, I believe, was identified through a mask that was on a social media page of his. Okay. And that's it. Okay. So we've got five individuals involved in an armed robbery. We've got an account, a let go account where someone was pretending to sell the alleged victim's merchandise. Okay. That account did not belong to my client. Okay. I don't have any information regarding any statements or anything that he may have made, but based on what I know at this point, Judge, it's not a very strong case against my client. Now, sure, a judge found probable cause to bring him here and have him before you today. However, for the purposes of bond, Judge, he is presumed innocent, and I think on all the IELA factors, he's a great candidate for bond. So we'd be asking for a reasonable bond so that he can, like I said, get out, go ahead and take advantage of some of the services and the mentorship that Next Level is going to provide. And I would like to ask his mother a few questions on the record, Judge, as well as Mr. Gary Davis, if now is the time to do so. Otherwise, I can wait until after the state.
No, now would be the time. And Mr. Johnson, so this would then turn into, I think, argued the bond the first time. Mr. Davis, were you present for that hearing as well? I know you have been in court a number of times on behalf of young men whose lives you're trying to assist. Were you here for Mr. Mapp back in May?
No, sir. I'm actually new to the case as well, so I wasn't there for that hearing.
Okay, thank you.
Yes,
And
sir.
Judge, that being one of the new circumstances that I thought made it proper to go ahead and refile for bond, Judge.
Okay. All right, Mr. Arnold, you can have either, is it Ms. Thomas who is Mr. Mapp's mother?
Her name is Princess Mapp. She is logged in under, I believe, Alicia Thomas.
Okay, so either Ms. Mapp or Mr. Davis, however you want to do it.
I'll start off with Mr. Davis. I'm going to call Gary Davis.
So they don't need to testify under oath. They are going to be providing something that you think is of evidentiary significance, and you can swear them in. Otherwise, it's fine for you to ask them some questions. I've heard from Mr. Davis on a number of occasions, and we didn't swear him in before. I trust him to accurately represent what his program does.
Okay, thank you, Judge. Well, even though the judge is familiar with the program, as it relates to Mr. Mapp, Mr. Davis, would you go ahead and just talk a little bit about whether or not you've had a chance to speak with him and your outlook as far as Mr. Mapp, his participation in the program moving forward?
Yes, I did have an, how you doing, Judge? Good to see you again. I did have an opportunity to interview Mr. Mapp when Mom initially reached out, and the fact that he was in college and he was heading in the right direction, he somehow got sidetracked. So I think, Judge, with the team that we have right now in place and the resources that we have available, I feel very strongly that our team will be able to put Mr. Mapp back on the right track to assist him to continue his goals that he has set in life for himself.
And Mr. Davis, are there currently partnerships that you have with other organizations or companies that would be able to provide job opportunities for Mr. Mapp?
Yes, one of our partners is UPS, Walmart, Home Depot. We have a number of companies that are, we just started our new professional development and entrepreneurship class. So if Mr. Mapp is interested in starting a business, we'll be able to support him with that as well.
Okay. And does anybody get a free ride in your program? Is this a program for kids who you feel cannot be controlled by the courts?
No, if it's, we get to a point where they're not cooperating, we have in the past and we'll continue to report them to the courts so that we can get it back in front of you, Judge, to see why he's not cooperating.
And I guess the last question is just the level of engagement. Is this something that he'll only be involved in one day a week? How can the level of supervision that you do provide ensure that he's not just sitting with mostly idle time?
Well, he's when the pandemic hit, we did not discontinue our service. Everything is virtual now. He's required to come to our classes every Wednesday night from 8 p.m. to 9 p.m. and on Saturdays from 9 a.m. to 12 noon. He will be assigned a mentor as soon as he's released. And also now that we're now transitioning back into place where we're meeting face-to-face every other Saturday. So his level of responsibility, he has a one-on-one with me once a month, and he has to report and meet with his personal assigned mentor twice a week.
Okay, and you're working with the family during the week as well, correct?
Absolutely. We do have a program on Mondays for the mother for a support system for her as well.
Okay. And has he already been interviewed and accepted into the program at this point?
Yes, he has.
Okay. All right. That's all I have for you, Mr. Davis.
Thank you.
Thank you, sir.
Ms. Hall, do you have any questions for Mr. Davis?
I do not, Your Honor.
Okay. Well, Mr. Davis, as always, I appreciate the work that you do in our community, whether it's the right fit for Mr. Mapp, we shall see, but I know that it's a valuable resource, and I appreciate that you make it available to young men in need in our system. Thank you.
Thank you, Judge.
And next, I will just ask Ms. Mapp, are you there? Princess Mapp, are you there?
I'm here.
Okay. I'm not able to see you there. If you would, just tell the court what your relationship is. Can you go ahead and tell the court what your relationship is to the defendant? Can you hear me, Ms. Mapp?
It's my son.
Okay. And does he live with you normally?
Yes.
Okay. And if he was released on bond, would he be living with you? And if so, could you just give us the general area of the city where you live?
Yes.
Okay. And what area of the city do you live in?
Yes, he will be living with me. I live in the West End, Adair Park community.
Okay, you're kind of going in and out there, but
community.
okay, you're kind of going in and out, but we're going to try to make it work. If he's released on bond, would you ensure not only that he abides by the court's orders, but would you also ensure that he's fully engaged in Next Level Boys Academy as well?
Most certainly.
Okay, and are you is there someone around the home who's usually able to supervise him throughout the day?
Yes, my uncle.
Okay, and does he have a good relationship with Mr. Mapp?
He does.
All right, that's all I have. Thank you so much.
All right, thank you.
Ms. Mapp, don't go away. This is Judge McBurney. I have a question for you. Was your son living with you back at the time of the alleged conduct in this case, which would be December of last year? Was he living with you?
He was living with me, but he was in college at the time.
Okay, meaning Atlanta Area Tech or Albany State?
I don't know, when did the alleged incident happen? Because he was in school the end part of last year. I don't know when it actually happened.
It would have been during winter break.
Okay, so he was home then.
Okay, and home would mean he was living with you?
Yes.
Okay. Do you have other children in the household, or is it just you and your uncle?
It's just me and I have a 2-year-old daughter.
Okay, and then your uncle?
Yes.
And he lives there with you, or he just comes by?
He stays down the street. He comes by and check on the house for me when I'm not here.
Okay. The address that I have for your son is on an Utoy, UTOY circle. Is that your place or someone else's place?
No, I recently moved from there. I moved to the West End area now. I'm no longer in that house.
Okay. And Utoy Circle is not in the West End?
No.
Okay, thank you. Ms. Hall, any questions for Ms. Mapp?
No, Your Honor.
All right. Anything else, Mr. Arnold?
Judge, that's all I have. Just to reiterate that on all of the other factors, my client is a great candidate for bond. I haven't been doing this for a very long time, but I've been doing this for long enough where I've seen a ton of individuals with far worse cases be given opportunities by the court. So I would just ask, considering his lack of criminal history, Judge, considering the opportunities that are awaiting him on the outside, possible mitigation activities that if we do end up having to submit a plea, Judge, that would certainly help his chances, of getting a better outcome. So also, if he does not, if he ends up beating these charges, we're asking not to interrupt his education to such an extent that it would be difficult, if not impossible, for him to get back on track. And with the pandemic going on, asking for a trial right now, it doesn't mean the same thing that it used to, Judge. So for all these reasons, we'll just ask that you release him on bond, give him a reasonable bond, and allow us to go ahead and start working on this young man.
Okay, thank you. Ms. Crawford, do you have any criminal history for Mr. Mapp?
Judge, Mr. Mapp does not have a criminal history.
Thank you. All right, Ms. Hall, you've told me about Mr. Mapp's case before, because I know we had a bond hearing, and I saw the order that I entered there, but you're going to need to repeat yourself because I'm not remembering all the specifics. I've taken a look at the indictment, so I understand we're talking about allegations from December of last year, multiple victims, Ms. Lopez, Mr. Garcia, and others. So it sounds like a very involved case. And I'm interested to hear what you have to say. In particular, the way this indictment is drawn up, all the counts charge Mr. Mapp as a party to the crime with persons unknown. And I heard Mr. Arnold say there were 5 people. So it will be helpful for me to understand the state's perspective to whether Mr. Mapp was closer to the merely present end of the spectrum or closer to there was only one guy with a gun and the state has these reasons to believe the guy with the gun was Mr. Mapp. That would be the other extreme.
Yes, Your Honor. So where do I start? So to remind you of this case, this is a family of 4 who found a phone on LedUp, and that was an iPhone 7 that they decided to purchase from. That account was not registered in the defendant's name. That account was registered to a Ty Monte. They were told to meet at a location. When they got there, an individual walked out to the vehicle. That individual apparently had a phone or maybe a phone in a box. He struggled to open the box to show the phone. The victim said that he was seeming very suspicious. And then he just darted back to the back of the apartment complex where they were sitting. They left, the victims left, and this was a family of 4, mother, father, daughter, and son. When they left, they got a call from a number, not the account that they had been dealing with, but just a random number. The caller told them to come back, and that he was having trouble with the phone, but that he figured it out, come back. When they came back, that individual plus 4 others came from behind the apartments and surrounded the vehicle. Mr. Mapp would have been identified as the person with the gun. There were several with guns, but this particular person was the defendant was a particular person that knocked on the driver door of this car, ordered the father to give up money, repeatedly told the entire family that if they didn't hurry up, that they were going to kill them, or he was going to kill them. He was identified multiple times by our victims as having a gun, being the person that was not merely present, but was one of the people that may have orchestrated this armed robbery. They did end up taking Ms. Lopez's purse, which contained 4 passports, 4 social security cards. That's their passports and their social security cards, as well as papers giving them authority to work. All this information had the victim's addresses on it. Of course, where they were currently living, where they currently still stay. They also took, I think, about $900 that was inside of the purse. After this situation happened, the victims reported this to the police. But while they were waiting for the police to investigate the case, the daughter also was investigating the case, trying to figure out who these individuals were, because it was 5 of them, and they have since been very terrified in this situation. So she thought that she could find out who they were faster. She somehow was able to figure out the phone number that called them that day was linked to an Instagram account tied to Mr. Mapp. She called the investigators, gave them this information. And while she was looking at the Instagram account, she did see that the Mr. Mapp had on one of the same masks that was worn that day. They were also able to listen to some of his videos or different things that he had posted, and they were able to identify him as being the person who kept, asking to give up everything and that he was going to kill them. Gave that information to investigators. Since we last had court in May, they have been able to identify the other 4 individuals. They did go and do a lineup for those individuals as well. The last time we were in court, we didn't know who those people were. The information has not been given to us as of yet from the investigating officer, but it is my understanding that all 4 have been identified at this moment. The state is asking, Your Honor, if the defendant can remain, well, we request that he remains in a no bond status. Nothing significantly has changed in this case since we had a bond hearing in May, other than this program. But this was, as you know, a very serious crime. Speaking of the Ayala factors, Mr. Mapp, although he doesn't have a criminal history, he is certainly a danger to the community. There are several people who shop and buy things off for offer up, and this was a stranger on stranger case. They were simply going to buy a phone, and they were approached by 5 individuals demanding all their property. And now, even though it's been almost a year, the victims are still living in fear because all of their personal items were taken in that instance, and nothing was ever recovered. So it wasn't even a situation where it was dumped and they were not interested. We don't know what happened with their things. So we certainly feel like if Mr. Mapp is let out on bond, whether he's a part of a program or not, he can certainly intimidate our witnesses. If he is convicted on these charges, he would be facing at minimum 10 years in prison, Your Honor. So we believe that he may not return to court to face these charges or to face these allegations, Your Honor. And we ask that if you do, or if you are inclined to give the defendant a bond, we ask that that bond be $200,000 total, and that he be required to wear ankle monitor. And Ms. Rolak, the victims are watching, but Ms. Rolak does have a statement from the daughter, who is the one who did a lot of the, she was very involved in the case. Her parents don't speak fluent English, so it was more of her speaking with the investigators and giving all the information, Your Honor.
Okay, thank you.
You're welcome.
Rolak, tell me, we'll need the name of the daughter and then what it is. Will she be speaking, or you have something from her that you'll be sharing?
I have something from her, Judge.
Okay.
I am a victim of this case. My name is Karen Garcia, Karen Garcia, and I am 16 years old. I was there that night when this crime happened to my family. To this day, that memory still haunts me. I believe that Larian Mapp should not be given a bond because he has become a threat to us. That day, he could have left me and my siblings without a father, or he could have killed us all because he was the one that physically pushed my dad's shoulder with his gun. Things could have been worse that night, but still could be if he is free. No innocent person should have to go through this because of someone's selfishness for money. No one should even have to wake up at night in terror, reliving an incident that should never have happened. Larry and Mapp and his co-conspirators have not only robbed us of materialistic possessions, but robbed us forever of our peace of mind. Consequently, if he is free, we will no longer feel safe in our own home because they took our personal information that has our home address and other personal details. Thank you for giving me and my family the opportunity to speak from our point of view. I hope Your Honor will seriously consider our safety when making your decision for bond.
Thank you, Ms. Rolak, and more importantly, thank you, Ms. Garcia, for putting words to paper like that. It's always important to hear from the folks who were affected by the incident, regardless of who did these things to you and your family. So I appreciate that and hope everyone is doing as well as could be hoped for in this situation. Ms. Hall, do you have anything else for the state?
Nothing further from the state, Your Honor.
Mr. Arnold, as the movant, I'll let you have the last word. Anything more you want to add about Mr. Mapp and his situation?
Very briefly, Judge, I would just add that it sounds like he was identified through a mask that was on his social media. From everything I've heard so far, I don't think anyone actually pointed at his face before seeing the mask on his page and saying that this was the person. Also, there seems to be some audio recognition. They're saying they may have felt like they heard him when he was speaking. Judge, I will remind the court that that is not a identification per se, and also, well, it's a form of one, but Judge, it's not nearly the same as pointing and seeing a face. And these were individuals. He's a young African-American man, is my understanding. These were Spanish-speaking individuals. So I would also call into question their ability to recognize his voice amongst the 5 individuals who were out there, Judge. So I'll rest on the rest of my arguments with that, Judge.
Okay. Well, I appreciate those points as well. I will take all this under advisement. Mr. Mapp, I will enter an order one way or the other soon. What I'll need from you, Mr. Arnold, and you can email it to Ms. Nelson. I'll need Ms. Mapp's address. It's not the address that's in the system anymore. We don't need to share it right now because this is a live hearing that's being broadcast, but I'll need that address because if I am going to set a bond, one of the requirements would be that Mr. Mapp be subject to pretrial supervision. They'll need to have a specific address where Mr. Mapp will be. If he has a curfew, that's where he'll have to be during certain hours. So we'll need that piece of information, and we'll take it from there. If Ms. Hall, if I don't grant a bond and this case becomes trial ready, meaning we give Mr. Arnold a chance to go through the discovery, and if there are not any motions, we handle final plea. Is the state prepared to try Mr. Mapp, even if the other purported co-conspirators have not yet been formally tried? I mean, formally charged?
Yes, Your Honor.
Okay. All right. So Mr. Arnold, please let Ms. Nelson know, one, that address, two, and this will come not as quickly as the address, whether you do have any motions that you're going to file because of the discovery that you get in the next week or so from Ms. Hall and her office.
I certainly will, Judge.
Okay, great. Ms. Hall, anything else from the state in connection with Mr. Mapp's case?
Nothing further from the state, Your Honor.
Okay. Mr. Arnold, anything else?
Nothing further, Judge. Thank you so much.
Sure. And just to repeat, there are 2 folks in court today here on behalf of Mr. Mapp. It's Mr. Mapp's father and a young lady sitting with him. So I recognize their presence as well as another indicator that there is local support and structure for Mr. Mapp.
Yes, Judge.
All right. Thank you, everyone. And thank you again, Mr. Davis, for dialing in.
Yes, sir. Thank you, Judge.
Thank you all. Have a great day.
All right, Mr. Mapp, Mr. Arnold will be in touch with you, letting you know what's happening with bond as well as all the discovery. Okay. All right. in is Mr. Yeomans.
Okay.
And that's a revocation, oh, and Ms. Hodge has it, all right. Hello, Ms.
Your-
Hodge.
Your Honor.
Your Honor, that concludes my business. May I be excused?
You bet, thank you, Ms. Hall.
Thank you.
Bye, Ms. Hall.
We don't have a lawyer for Mr. Yeomans.
I'm going to go with you.
You can just take a seat. We gotta work through representation here. On the calendar, it says Ms. Davis. I'm not familiar with the name. She may be with the Public Defender's Office. Ms. Hodge, have you dealt with anyone in connection with Mr. Yeomans?
I have not, Your Honor. I was hoping someone would be on Zoom because I haven't heard from anyone.
Okay. Do you pronounce your name Yeomans or Humans?
I say Yeomans, my family say Yeomans, so I'm going back. I'm like,
I'm going with yours. So Yeomans it is. Mr. Yeomans says it is Yeomans. His mom might correct it, but she's not here. Mr. Yeomans, have you talked with anyone about the revocation proceeding we're gonna have here as a lawyer talk to you? Okay, we need to make that happen soon. Ms. Nelson, any sense from your side as to who might have this case? It ends in a 1, so that would be Mr. Franklin if it's going to.
Correct, and it's an old Judge Downs case, it looks like. Let me reach out to Mr. Franklin and see if he knows anything about it.
Okay, thank you. We're not gonna do anything official with your case till we get a lawyer for you. Your case is old enough that whoever was helping you with your case back in the day is not still assigned to this case, may still be around, but I'm looking it up now as well. Do you recall, was it a public defender who helped you, or did you hire an attorney?
no, I was like,
Okay, well, the 2 public defenders in this court are great. Seriously, this says Dempsey on it. I wonder how it got to us. Old indictment. So you pled guilty. Final disposition in August. Wow, it was 9 years ago. Okay, so it was 20 to do 2. So you had 2 years in custody and 18 years of probation. You're still on probation. Judge Dempsey. Revocation in front of Judge Dempsey. You've had trouble finding addresses that work.
that's the problem the whole time.
Okay. And that's the allegation here. And again, we're not going to get into the substance of it, but that was a problem in 2014. Like, sort of in 2015, but that was Dempsey again. Ms. Nelson is trying to reach one of the public defenders. Okay. How old are you now?
31, sir. All right, Ms. Patel is going to join us just to serve as a bridge between Mr. Yeomans and maybe getting Mr. Franklin to handle this matter. But it may be that the two, well, Ms. Patel is going to need to talk to Mr. Yeomans either way, so we'll see.
So, Your Honor, for clarification purposes, are we moving forward with the probation revocation today?
Probably not. That will be up to Ms. Patel, but I assume she'd want to talk to Mr. Yeomans and vice versa. And so more so, I just want Mr. Yeomans to see someone and hear someone who can say, I may not be the one handling your case. It may be my partner, meaning Mr. Franklin, but we can't track Mr. Franklin down right now. Ms. Patel has agreed that she'll dial back in.
Okay, I do have the probation officer, Mr. Scaffey. I'll just send him a message and ask him to just hold tight.
Okay.
Thank you.
Judge McBurney.
Yes, ma'am.
This is Ms. Crawford. I just had a question. If we don't get to address the revocation today, is there any way the probation officer can provide me with anything that we may need just in case he's unable to meet back for the next court hearing or the next court date?
Sure. I think that's Officer Scaife, who I can see right there. I'll hear from him in a second. I just want to get Ms. Patel on. This petition doesn't strike me as one that's going to lead to a big fight. I would think that Mr. Franklin or Ms. Patel will be trying to work it out. The allegation is that Mr. Yeomans is hard to find, and he acknowledges as much because he is housing challenged. It actually says in Odyssey, if you look up what his address is, it says Augusta, and that he's housing challenged because he has to register. And so there are many fewer places that work as a residence for him. So I'm not committing anyone to working the case out, but I don't know that it's one that would result in a big messy revocation hearing. But we'll get Ms. Patel on and make a plan.
Okay, thank you.
Sure. Did you get picked up in Augusta or up here in Atlanta? Hey, Ms. Patel.
Good morning or good afternoon.
Good afternoon. I appreciate you dialing back in even after we all agreed you were done and could go about your business. I'm going to ask you to substitute briefly. I suspect it will be a substitution for your colleague, Mr. Franklin. We have in court right now Mr. Yeomans, that's Y-O-U-M-A-N-S, and he pled guilty in 2011 to statutory rape and I think child molestation. Either way, they were offenses that required him to register. And as a petition and warrant for revocation that is predicated on basically being hard to find. And we're right now trying to find him the person who will represent him. We don't necessarily need to resolve this afternoon, although I'm sure Mr. Yeomans will have to resolve it soon. Tell me your understanding. The case ends in a 1, and it's from 2011. How is this most likely going to be assigned, assuming it flows through your office and you have no conflict, which seems like would be the case?
Right, so that would be Mr. Franklin's case. But I'm happy to sub in just for now to see if I'm not sure if Ms. Hodge had any type of offer or resolution for the revocation.
So we'll hear from her in a second, just to put a little more context on it. The allegation that Mr. Yeomans became hard to find because he wasn't at his grandmother's home these are all from March and February of 2018. So Judge Dempsey signed the warrant in April of 2018, 2.5 years ago almost. And it only recently caught up with Mr. Yeomans. I've already asked Ms. Nelson why we're hearing this. I think it should go to Judge Millender because it was a Dempsey case, but for now we've got it, and I don't want to give Mr. Yeomans more of a runaround than is absolutely necessary. It's not your case. It would be Mr. Franklin's, but 2, maybe neither of your cases.
Right.
Judge Millender. However, he allegedly violated his probation by not reporting, and that was 2.5 years ago. How long have you been in jail, Mr. Yeomans? Ballpark. Okay, you've been in for about a month. Ms. Hodge, if you had had a chance to pre-try it with a lawyer for Mr. Yeomans, what would you have been recommending?
I would have been recommending that 2 years be revoked, Your Honor. My main concern is that he had a probation revocation hearing February 16th, 2018. And at that time, it was determined that he could continue on probation, and he was instructed to report to probation after that revocation hearing, and he never did, Your Honor. And I understand that he's challenged to find housing. However, that doesn't prevent him from calling in or making contact with his probation officer. And this, in my opinion, was just he just thumbed his nose up at the court. So where he has been free to not have to report for the past 2 years, I would ask that that 2-year time be revoked.
Okay, I understand that perspective. That says to me, we're probably not going to sort it out today.
Right.
So what we need to do is, my staff and I need to do 2 things. 1, we need to figure out Millender or McBurney. And if it stays here, 2, we need to get this on Mr. Franklin's radar so he can see Mr. Yeomans, they can begin talking. And then Ms. Hodge will know, with whom do I discuss the case? So Ms. Patel, it was very helpful that you dialed in. I'm not feeling like you're dodging it. If the way this case had shaken out, that it was, hey, a time served, we could probably do it today. But that's not the state's recommendation, and I fully understand why. So what we're going to do, Mr. Yeomans, is very soon, can't give you a specific date, but we'll figure out, is the case staying here, or does it go to my colleague? And it's a colleague who moves her cases along, so you're not going to get stuck. And if it stays here, then we need to get Mr. Franklin, who works with Ms. Patel. Just heard her voice, and you may have seen her on the screen. She's kind of small from that distance. She and I will make sure Mr. Franklin gets with you to start figuring out what we're going to do. Okay. Do you have any questions about any of that? Other than when will I be back in court? Okay. We'll get you back in court soon. In the meantime, do you have a spot where you're staying? If you get, let's pretend, I'm not promising you anything, that the way this played out was, all right, time served, you did a month or you did a month and a half. Is there a stable address where you would go, or is that part of what Mr. Franklin or one of his colleagues needs to be working on?
Situation kind of bad when my parents passed. There's nowhere that I can go in Atlanta, being that being a rock.
Yeah.
What happened was a while back I did a state comeback service family in South Carolina. But a bunch of stuff happened on their end where they granted it. I went there, and then when I got there, I reported everything was fine in the next court.
Okay, I saw something, you were in front of Judge Woodson, who handles some of these things, that mentioned South Carolina. I didn't understand what that was about. So you tried to get to a good, safe space. South Carolina is not obligated to take Georgia cases. They did for a little bit, and then they said no more.
No, it wasn't that. I had an old warrant down there for something I did when I was a child. So basically, here, I was thinking the smart way to do it would be, okay, since I can't find any address here, you already have to come pick it up.
Right.
Just do the interstate complex, so I can stay there because I have addresses there that fit the requirements of being there.
Yeah.
Once I got down there, they didn't let me out immediately. I had to stay in jail about 9 months.
Oh.
But people here didn't know that, so they thought that I got out when I went down there.
And then you weren't registering or plugging in any way.
So here, they just withdrew it, not even knowing that I was out.
Okay. Well, there may be a chance to do it again, and that's where Mr. Franklin or someone else from the PD's office can explore that. So appreciate you sharing that. And Ms. Patel, if this ends up being Mr. Franklin's case, if you can try to remember, and I will as well, to let Mr. Franklin know housing or a transfer to South Carolina ultimately is going to be an issue for Mr. Yeomans. After we work through the revocation, he may be our guest for a while, depending on how that plays out.
And Your Honor, just for a point of clarification, because I did just look at the calendar, he's also on the calendar for an open case. Is that correct?
The calendar says.
Yes, that's what he's on the calendar for, open case 15 SC 138346. That's the one that was originally assigned to Judge Downs. I think the comments are to the probation revocation.
Right, and the open case and the probation case both stem from the same incident.
Got it. The open case, the 15 SC, is a failure to register flowing from the conviction in the 11 SC.
Correct.
Okay, and that's why it's probably the case that the 11 SC revocation ought to go to Millender, but if we've got an open case, it actually is open, we should just wrap you up, and I would offer that up to Judge Millender anyway. So that case ends in a 6, Ms. Patel, ding, ding, ding.
Right.
I don't know who Shavantana Davis is. Is that a former colleague of yours?
Yes, she did used to work for our office, so that will be my case.
Okay.
And I'm sorry, could you say that again?
It's good you're on the call.
Right. And I'm more than happy to also handle the revocation as long as that's not an issue with Judge Millender.
I will clear that up. Allow me to clear that up, and Ms. Nelson will let you know, but assume that the revocation will follow the 15 SC. I apologize, Mr. Yeomans. The piece of paper I had in front of me is the warrant from your old case that you pled to back in 2011. But also in front of me was a piece of paper with a 15 case from 2015. You were indicted about 5 years ago for failing to register in June of 2015. And who knows if that's wrapped up with South Carolina or Augusta or what. Today's not the day we're going to talk about that. That's an open case, and you're going to stay where you are until we resolve that as well. But it sure does seem, Ms. Hodge and Ms. Patel, that we would be able to resolve them both together. Maybe
Right.
not negotiated, but that they could be wrapped up into one disposition. I think they're sort of symptoms of the same situation.
Correct.
Okay, I'm sorry for that confusion. I overlooked that the case on the calendar was not the 11 SC, but the 15 SC. I'll reach out to Judge Millender, assuming she greenlights it, we'll keep the revocation part. And then I guess, Ms. Patel, you and Mr. Yeomans need to figure out a time when you can connect and develop your perspective on the case. And we'll benefit from Ms. Hodge being plugged into both those pieces.
Will do. And I apologize, I missed that case would have been our office's case on the calendar.
I did too. It would be great if you would file a waiver of arraignment if that's what you and Mr. Yeomans decide you're going to do in the 15 case. And that would get your name in the record, Ms. Patel. And Mr. Yeomans was on a plea and arraignment calendar in December of 2015. But then there's a hold that was entered, and Mr. Yeomans was extradited to South Carolina, and who knows what happened. So
Right.
It would be cleanest if you entered that waiver of arraignment, or we got Mr. Yeomans on a Zoom call and he was formally arraigned. One way or the other, but let's take care of that.
I can do that by the end of today.
Okay, super. Mr. Yeomans, there's an added wrinkle to your situation. There are these 2 cases that we're actually working through. So we'll certainly keep working together, because the newer case, the failure to register, that's my case. I don't send that to anyone. I'll probably try to pull the revocation in here as well. You're going to want to connect with Ms. Patel. She'll make that happen, whether it's through the phone or she comes out to the visitation place when she's able. That doesn't happen every day. And then Ms. Patel will let us know when we should put this case back on the calendar to see what we can do with it, okay? All right. Officer Scaife, you've been very patient on the line here. I don't think we need to get anything more from you. Ms. Crawford, did you have any questions of him? We wouldn't be handling just the revocation now. We would be figuring out how we're resolving the newer case at the same
No, I didn't have any questions.
Okay, all right, great. Well, thank you, Ms. Hodge, thank you, Ms. Patel, and Mr. Yeomans, we'll get you either virtually, or you'll be at the jail, but on one of these screens, or on Tuesdays, we bring people over to figure out what's next with your case, okay? All right, thank you, everyone.
Thank you, Your Honor.
Judge.